Now let's look at Regents of the University of California versus Bake. We know that in Brown versus the Board of Education, the Supreme Court of the United States ruled segregation by race in public schools to be unconstitutional. But in this case, it upheld affirmative action, allowing race to be one of several factors in college admission policy. Although they also ruled that specific racial quotas, such as 16 out of 100 seats set aside for minority students by the University of California, Davis School of Medicine, were impermissible. Now let's look at Hopwood v. Texas. This was the first successful challenge to a university's affirmative action policy in student admissions since Regents of the University of California versus Bake. In this case, 4 white plaintiffs who had been rejected from the University of Texas at Austin School of Law challenged the institution's admissions policy on equal protection guards and prevailed. The court held that the University of Texas School of Law may not use race as a factor in deciding which applicants to admit in order to achieve a diverse student body.
The problem that we're facing now is whether the government has the power to try a private university and rule their policy as unconstitutional. All previous court cases regarding affirmative action have been in the context of public universities. Cases such as Regents of the University of California versus Bakey, Hopwood v. Texas, or Johnson versus the University of Georgia are all landmark cases that could provide viable precedents for the potential case. However, the problem is that they call on the Equal Protection Clause for evidence that affirmative action is unjust. The problem now comes to mind of whether the Equal Protection Clause applies to private universities or if they are exempt from it due to their nonprofit status. Now, this case has been in the works since 2015 when several Asian American groups pointed out the discriminatory policy in Harvard's admissions process. The time it has actually taken to reach the point of becoming a viable court case is what is truly concerning, though. The reason it's taking so long is because the court needs viable evidence in order to try the issue. This was seen in 2006 and 2011 with the University of Princeton, in which charges were pressed because of discrimination in their admissions process. However, both attempts failed because the proper evidence was not brought forth. Barring whether or not the court actually has the power to put a private university on trial for this issue, if they're not able to produce the proper evidence, then the case may not proceed at all.
60 different groups, including the Asian American Coalition for Education, filed a complaint with the Justice and Education Departments claiming that Asian Americans are held to a different standard, a higher standard, than other students applying for admission at elite universities. The Department of Justice agreed to investigate this claim, and if discrimination is found to be present against Asian American students, then a potential legal battle could resort in the Supreme Court case of United States versus Harvard. To understand this court case, we have to understand the culture of American citizens in regards to affirmative action. Early affirmative action laws required that government employees not discriminate against any employee or applicant for employment because of race, creed, color, or national origin. However, progressive activists didn't feel like ending institutionalized racism was enough. In other words, equality of opportunity had to be followed to the extent of leveling the playing field, even if that meant giving underrepresented minority groups a preferential treatment. This led to the creation of laws that allow state and federal governments to favor women-owned and minority-owned businesses when awarding contracts, and to reject bids from businesses that only hire on the basis of qualifications and do not make efforts to include minority-owned businesses among their subcontractors. Laws such as these indirectly encourage the private sector to take race into consideration when hiring employees, admitting students, or giving promotions, as the Constitution cannot allow federal government to compel the private sector to hire minority individuals. All it can really do is pass laws that render discrimination illegal. Interestingly enough, race quota systems have been found unconstitutional as demonstrated in 1978's Regents of University of California versus Bakey, since it violates the Equal Protection Clause in the 14th Amendment. With this information in mind, it brings up several questions in regards to the Harvard case. How is Harvard University to balance including a diverse campus and admitting almost entirely on the basis of qualifications? To what extent can Harvard give preferential treatment to various racial groups given that they are a private university, And does Harvard's admission program violate Title VI of the Civil Rights Act of 1964 that states that discrimination cannot be on the basis of race, color, or national origin? The answer to this question lies in the holistic college admissions, which is a policy based on the idea that a test score or GPA does not completely reflect who a student is and what he or she can bring to a college community. It allows a college to factor in the student's background, challenges they overcame, extracurricular involvement, letters of recommendation, special talents, writing ability, and many other criteria. Private schools and many public universities can include race among the characteristics they consider, as long as they don't apply racial quotas. Therefore, with holistic college applications, universities can legally look at race as a determining factor if applicants have already had similar qualifications. However, a 2002 Princeton study found that Asian Americans, to get into top universities like Harvard, must score 140 points higher than white students on the SAT, 270 points higher than Hispanic students, and 450 points higher than black students. These numbers are based on the 16-point SAT. The 5-4 conservative Supreme Court majority could very well cite such information as violating the Civil Rights Act of 1964 and declare such affirmative action policies as illegal practices. Now, is affirmative action really about assisting minorities in American society and not a weaponized political weapon that causes Americans to still argue and fight one another over privilege and race relations, and not about critical issues like how the federal government taxes income so that it can pay interest on a debt that will never go away since more debt exists than money? Of course not.